The Colorado Supreme Court now says that it is constitutional to require a mass shooter to stop and reload after 15 bullets. The court upheld today the large magazine ban that was put in place after the Aurora Theater shooting in the hopes of slowing down what we cannot seem to stop in America. The gun rights group Rocky Mountain Gun Owners sued over that, and today, 7 years later, they lost. Again. Our Marshall Zellinger explains why this ruling might not matter.
It's a law that's been on the books since 2013, and a law that 9 Wants to Know found is not being followed. The sale and transfer of magazines that hold more than 15 rounds of ammunition. Right after it passed 7 years ago, Rocky Mountain Gun Owners sued. Today, the Colorado Supreme Court unanimously disagreed with their arguments.
What they're saying is the large capacity magazine ban doesn't really interfere with someone's right to defend themselves, their property, or their home.
Attorney Christopher Jackson helped us understand the 46-page Colorado Supreme Court ruling, which referenced Columbine and the Aurora Theater shooting. Both involved shooters with gun magazines that held dozens of rounds of ammunition. The pause created by the need to reload or replace a magazine creates an opportunity for potential victims to take life-saving measures. In short, the evidence overwhelmingly demonstrated the reasonableness of the General Assembly's choice to set a limit on the number of rounds that can be fired before a shooter needs to reload. The Colorado Supreme Court ruling cannot be appealed to the U.S. Supreme Court because Rocky Mountain Gun Owners only challenged it based on Colorado's Constitution and not the Second Amendment of the U.S. Constitution.
The reason we didn't file in federal court was there was already a federal court lawsuit in 2013.
RMGO's executive director, Dudley Brown, also said the 2013 makeup of the U.S. Supreme Court played into the decision to keep this a state case, which he says cost $210,000, funded by small donations from gun owners. RMGO also needed that money when it challenged the red flag bill last year and the process the state legislature took to pass it. RMGO lost that court challenge last month.
If the only fights we ever started were ones we were guaranteed a victory in, we would never start a fight. And sorry, that's not what our members want.
Does it even matter? Last fall, a 9 Wants to Know undercover investigation found gun stores selling parts kits, large capacity magazines sold in pieces, ready to be assembled after being purchased. Stores in Weld County and El Paso County sold the magazines fully assembled. Today, we called the 7 stores we found selling parts kits or large capacity magazines as is. 6 of them continue to sell them. The 7th didn't answer the phone. If a law is passed, signed into law, upheld by the Colorado State Supreme Court, and not enforced, does it make a sound? Tomorrow on Next, Kyle, we'll hear from Republican sheriffs on if this decision changes their thought process on how they have not necessarily been enforcing the current law as it relates to parts kits.
Marshall, they were some of the earliest opponents of this, saying we don't support it. If you put it in place, we won't enforce it, as you went in and saw.
Yeah, and we've heard from today's decision that because the Supreme Court didn't make any comment about parts kits, that leaves it as a gray area, perhaps as something legal to sell, though we've heard from the Attorney General's office that it is not.
All right, Marshall, thank you.